May proceed, CJ.
Okay. Good morning, councils. Before we call the case, I want to thank you for your continuing assistance and cooperation in our virtual courtroom. We want to continue with our oral arguments, and the platform allows us to continue to do that. So with that, will the clerk please call the case?
This is Supreme Court case number WRM20-001. Mark A. Torre Jr., petitioner, versus Superior Court of Guam, respondent, and the people of Guam, real party in interest. Appearing for the petitioner, Mark Torre Jr., is attorney Anita Areola. Appearing for real party in interest, the people of Guam, is attorney Marianne Wolashuk. Appearing for respondent, Superior Court of Guam, is attorney Serge Kenga. Attorney Areola reserves 7 minutes for rebuttal.
Thank you. Attorney Areola, you are recognized.
Good morning. Mr. Chief Justice, may it please the court. On October 1, 2019, my client, Mark.
Areola, yeah. I have a preliminary question.
Yes.
Your entire argument is based on the assumption that 8 GCA section 8060 applies to retrials on remand. Could you explain why you think that section applies?
Because that is the statute that controls when a defendant is going to be going to trial. And it doesn't make a difference or a distinction between trials or retrials. My client was arraigned in this case after the amended indictment was filed, and section 80.60 does not say otherwise, that a retrial has to be treated differently. And because of that, the statute clearly applies. It says that trial must be commenced within 60 days of his arraignment when he's not in custody. And for that reason, section 80.60 applies in this case.
But if you have a remand where there is no arraignment, when do you start the time running according to the statutory terms?
When there is no arraignment?
Yes.
Then I believe when the defendant asserts his right to a speedy trial, which is something that we did in this case as well. We asserted it on October 2019 when the amended indictment was filed. And so the right to a speedy trial, whenever that is asserted, that's when the time would start running.
Where in the text of 80.60 does it say that?
It doesn't say that, Your Honor, but the clear terms of the statute are that whenever you have an arraignment and whenever you have a defendant who is getting ready to go to trial and is not in custody, then trial commences 60 days from the date of his arraignment. And in this case, you know, Your Honor is really talking about a hypothetical because that didn't happen in this case. In this case, there was an arraignment, an amended indictment was filed, and my client asserted his speedy trial rights on October 1st, 2019. To find otherwise would mean that my client does not have a right to a speedy trial at all on remand. And that certainly can't be the case.
Isn't the Sixth Amendment a sufficient protection?
No, because this court has held that the Sixth Amendment constitutional right could not be appealed or taken up on a petition for a writ of mandate, only a statutory violation of the right to a speedy trial. And there's nothing in our Guam statutes, in this court's precedents, or on Sixth Amendment constitutional law that requires that kind of an outcome. And it would limit all defendants who are on remand to having virtually no statutory right to a speedy trial. And that's certainly not what 80.60 is required or intended to do. In this case, my client asserted his right to a speedy trial on October 1, 2019. He signed a simple statement regarding speedy trial, and that statement reflects Mr. Torre's assertion of a fundamental statutory and constitutional right that Mr. Torre is entitled to a speedy trial. Guam's Speedy Trial Act, which we just discussed, provides that a court shall dismiss a criminal action if a person charged with a crime who is not in custody at the time of his or her arraignment is not brought to trial within 60 days of the arraignment. Dismissal is mandatory unless good cause is shown. It is undisputed that Mr. Torre was not in custody. It is further undisputed that he was not brought to trial within 60 days of his arraignment. The
Ms.
lower court,
Ariola, can we focus on the trial commencement date? Is it your argument that speedy trial commences at voir dire as long as the court acts in good faith, or that it starts at a different time?
no, the test we believe is one that was articulated by the California Supreme Court in a statute that is our predecessor statute for the Guam Speedy Trial Act. And in that court, it held that trial commences upon voir dire of potential jurors when a trial judge is ready and available to try the case to conclusion. And that was not the case here. We did not have a trial judge who was ready and available to try the case to conclusion. The lower court.
So irrespective of, because the Reinhardt case, which is, I believe, the case that you cited, it appeared that the focus was on the reason for conducting the voir dire. And in that case, the trial judge told the parties that the only reason he was impaneling the jury was to avoid a dismissal under the California counterpart 1382. And so the court, the appeals court determined that they did not, the judge did not act in good faith, and therefore that was not when trial commenced. So shouldn't the focus be on the good or bad faith of the judge rather than examining the test of what was the reasons for the delay, as you set forth, and whether the judge was capable of handling the case until the conclusion? Because it
No,
seems
Your Honor.
that, okay, go ahead.
I don't believe that that's the test in Reinhardt. The Reinhardt test seems to be twofold. One, the test is, was the trial judge ready and available to try the case to conclusion? That wasn't the case here. The second part is, certainly the facts of that case was that the trial judge specifically stated on the record, I'm just doing voir dire in order to avoid the speedy trial clock. But that's not the holding of the Reinhardt court. The holding is actually, was there an intent to merely pay lip service to the Speedy Trial Act? And the answer on this record is yes. The January 8th memorandum issued by Judge Bordallo before voir dire began on January 8th was before January 10th when voir dire began. On January 9th, in a chamber conference with counsel, Judge Bordallo informed the parties he intended to resign, that he would continue to select the jury, and he would decide the motion in limine. Then on January 22nd, Judge Bordallo said he would resign soon and that a new judge would take up jury selection and decide the motion in limine. He instructed the parties to issue subpoenas for a trial date of January 27th, 2020. He abandoned the case on January 22nd, but remained on the bench, hearing and deciding other cases until February 13th. On these facts, there is no other conclusion but that although he started voir dire, Judge Bordallo was never going to try the case. And he never did. That's intent.
So it's, Attorney Ariola, you are assuming that under the Reinhardt test, that it has to be the same judge who has to be normally available and ready to try the case to conclusion. Is that your position?
I am assuming that, Your Honor, but I can envision a scenario where there's an available trial judge and he hands it off to someone who is available and ready to take the case. That might have happened, for example, on January 9th, if a new judge had been reassigned to this case, but those are not the facts here. What happened here was that we have a trial judge who began voir dire on January 10th over the objections of the defendant, commenced it again on the 14th, stopped and commenced it again on the 17th, stopped and recommenced it on the 21st and the 22nd, and then nothing happened until we had a reassigned
Didn't he
judge.
say beforehand, before the voir dire, that didn't he inform counsels that he would not likely be available to conduct the trial, but he would handle the jury selection, but that he, because of his impending move to the district court, that he would not likely be the trial judge that would actually handle the trial. And that's why I asked you the question under Reinhardt. Is it your position that when it says a trial has commenced for speedy trial purposes, when a judge is normally available and ready to try the case to conclusion, does that mean that it has to be the same judge?
It should be the same judge. And if it's not the same judge, then there should be a good reason for why we have a transfer judge or a reassigned judge. But even if we do have a reassigned judge, that didn't happen here. It didn't happen.
This question. So if we assume that it has to be the same judge, is your position? Or so if in this particular case that Judge Berdaliu had impaneled a jury, prosecution had called the first witness, and then for some reason he became ill and was not able to handle the trial to conclusion, and an alternative judge steps in, then is your client's speedy trial rights violated because the judge was not available to try the case to conclusion?
It depends, but Your Honor, that's not the facts of this case. What happened in this case was that we had an assigned judge who was never going to try this case to conclusion. And what happened was that Judge Berdaliu was not alone in paying lip service to this case. The whole Superior Court paid lip service to this case. And Your Honors, this is where it's important to reiterate and restate that the Superior Court is not one judge. It's all of the judges, and the Superior Court in its entirety paid lip service to the Speedy Trial Act because it didn't reassign a case in a timely manner. This is where the lower court found that the reassignment of the case to another judge was a circumstance constituting good cause to delay trial. But Judge Berdaliu's January 8th memorandum completely undercuts this holding.
But isn't it a possible remedy for that for purposes of determining the computation of speedy trial rights, if we were just to discount all that time period and not count it as tolling the 60-day time period? Wouldn't that address that we don't attribute any tolling to the actions of the administration in reference to the running of the 60-day time period?
You could do that, but the problem is that we still have all the other issues that are raised in this case, which is whether or not the first motion to dismiss told the speedy trial clock and whether or not the motion to eliminate told the speedy trial clock.
Before we get to that, because I think this case is this issue raises an issue of a threshold issue, and it's a case of first impression, and that is which test do we adopt for purposes of determining the commencement date of the 60-day speedy trial time period? Do we adopt a Reinhardt two-part test, or we follow the trial court and adopt the federal test under that it's when voir dire starts in good faith, that is the commencement date, because you are advocating that our court adopt the Reinhardt test, and my initial question regarding that is that this test is very fact intensive, and the fact that you can bring it up on a writ of mandate, as we said, a writ of prohibition in violation of speedy trial rights, put us in a position where now we become fact finders. Isn't that inviting this court to be unnecessarily tangled into the fact-finding function? When is the trial judge available to conduct the case to its conclusion? I think we just raised an example in terms of someone who becomes medically ill. So what type of guidance can you offer the court that we won't be necessarily caught up and we'll see the floodgates open of all of a sudden all these writs being filed because they don't agree that the trial judge is available to try this case to conclusion, or that the resources of the court has been committed?
Well, Your Honor, let me first say that this court has already developed a substantial body of precedent on the right to a speedy trial that is very clear, very consistent, and very significant.
And isn't it true that under that statement that we have then favored the bright line rules? I think you're referring to Roussel, the prompt arraignment statute, in which we said it's a period of 60 days. And we favored bright line rules in this area of speedy trial, so we can provide the bar with more guidance and not get involved in these fact-intensive reviews.
But Your Honor, even a good faith test would involve a fact-intensive question of whether or not a trial judge acted in good faith in commencing voir dire of potential jurors. I mean, I think the test that's in Reinhart is not fact-intensive. What it is it's a test and a balancing between a defendant's right to a speedy trial and whether or not just commencing voir dire in terms of paying lip service to the Speedy Trial Act is really going to cut it for a defendant. And Your Honors, I can tell you that as a matter of fact and as a matter of practice in the Superior Court of Guam, we have voir dires commencing all the time of potential jurors, and then nothing happens for days or weeks. And that's what happened in this case. In this case, voir dire commenced on January 10th, and as of today, the jurors are still sitting there. They're waiting. They were waiting on January 22nd. They were waiting on February 4th. They were waiting on March 4th when we filed this petition for writ of mandamus. And so the court has to come up with a test that I don't think that the test in Reinhart is good faith. And I think that's way too low a standard to hold the Superior Court of Guam judges. But I think the two-part test in Reinhart is very telling.
Why should we not adopt the federal test? And that is what trial commences under for the speedy trial determination purposes upon voir dire occurring. And that's exactly what the trial court implemented in this case.
Well, because federal decisions don't normally apply in our cases involving the right to a speedy trial, usually those federal court decisions determine their case law based upon the Federal Speedy Trial Act. And this is not a federal court. This is a Guam court. And the court can interpret its Guam Speedy Trial Act according to how it sees fit. But Your Honors, there's a big difference between the Federal Speedy Trial Act and our Guam Speedy Trial Act, and that is that there are specific deadlines contained in that case that act as a speed check or a check on trial judges as to when and where and how they can decide motions and how they commence voir dire. As we cited in our brief, the federal court decisions where they have held that voir dire commences a trial are based on the fact of a Sixth Amendment violation, not a violation under the Federal Speedy Trial Act. And it was hand in hand with other federal court decisions as deciding or interpreting the Sixth Amendment right to a speedy trial. That's not what's present here. This is not a Sixth Amendment right case. This is a Guam statutory speedy trial case. And I think it's incumbent upon the court to develop its own test, our own law, just as you did with the right to speedy trial decisions in the last 20 years, in order to come up with when trial commences in this case. But even the federal—
I know that we are quite capable of doing that, but I think what I'm searching for is some guidance in reference to the two elements of the Reinhart case. And if you're saying that good faith, bad faith is not a factor to determine in reference to the test, then I believe that it is a very fact-intensive review. And I'm concerned that since we've announced that you can take up a alleged speedy trial violation through a writ, that there's going to be a multitude of different of opinion as to when a trial judge is ready and capable to take this case all the way to conclusion. And does that mean it's the same judge? What does it mean to conclusion?
Your Honor, the two factors or the two standards or tests in the Reinhart case are very easy to follow, and all the California cases that have construed and followed that decision have not come up with the plethora of cases that Your Honor is envisioning that would come up to the Guam Supreme Court. The first test, whether or not the judge is available and ready to try the case conclusion, that's an easy question here, because on the record, there was the January 8th memorandum that anticipated and foresaw that there was going to be a resignation of this judge. On this record, surely this court cannot find that that test hasn't been made or met. And then the second test is whether or not there is an intent to pay lip service. And again, on this record, both Judge Bordallo and the Superior Court paid lip service to the act. There was no reassignment of a judge in a timely manner, even though they knew about it in the January 8th memorandum. And even though Judge Berdalio told them and warned them, you know, it was like a 3-alarm fire. Listen, this is an asserted case. This is how many days remain on the speedy trial clock. I'm leaving, and you need to reassign this case. Okay.
So if we give you that and we discount all that time period, and we then focus on the motion to dismiss and the time period that it's told as a result of that, and the motion in limine, maybe we should go through that exercise and see if in fact that any delay, as you allege, on this on the part of the Superior Court administration violated your client's speedy trial rights, then why don't we focus on those two and see what is the effect of filing those motions and the tolling of the speedy trial rights to determine if your client was prejudiced as a result of Judge Barcenas not taking on this case until a few weeks after Judge Berdalio stepped down.
Yes, Your Honor, that's the first circumstance that the trial court found constituted good cause for delay, and that's the first motion to dismiss. The first motion to dismiss the amended indictment was filed on October 8, 2019. 48 days elapsed from October 8 to November 25th when the assigned judge denied the motion to dismiss. That is 48 days, 80% of the 60-day time limitation under Section 80.60A2. The lower court explained that the first motion to dismiss required a complex analysis of constitutional law from other jurisdictions.
Let me focus, Ms. Areola, on the time to decide the motion to dismiss the indictment. You assert that that was an inordinate and unreasonable delay. Is that because of the time it took to decide that, or was it because of the failure of the judge to set forth within his decision that the time taken to decide that motion was reasonable?
It was both, because under this court's precedents, the court has to do both. It has to decide a motion within a reasonable period of time, number one, and number two, it has to give reasons or a statement discussing why the period of delay occurred, that this motion was either novel or complex, or that there was a good reason for the delay, and neither is present in the record or in the decision itself.
So in this case, I mean, there have been prior cases where we've determined, I believe, and even in the Abanas case, a district court appellate division, there was 30-some days to decide a motion that was not deemed unreasonable. And here on a typical motion practice under the local rules, you'd have a period of time for the government to submit their opposition and then you to submit a reply. And in this case, there was only 24 days after the court took the motion under advisement for it to reach its decision. Obviously, this is not a federal case, but in the federal speedy trial, the time limit for a period when it's under advisement by the court, as long as it doesn't exceed 30 days, it's not deemed to be an unreasonable period. And so on its face, it's not so apparent to me necessarily that the time frame from the filing of the motion to the conclusion of the motion and when the judge took it under advisement was per se unreasonable or inordinate. And obviously, the decision doesn't contain, magic words that, if you would call them that, the magic words that the motion raised complex or novel issues. And I don't read Nicholson as necessarily mandating that those words be present in every motion. I think we have to look at the record as a whole and determine, when you look at the record, is it a reasonable period of time? Because I can envision a circumstance, for example, where it's a pretty simple motion, but the judge writes in the motion, oh, this is a complex motion, and therefore, it took me a long period of time to decide it. or if it's a very complex motion, it's apparent from the substance of his decision it was complex, but he doesn't put anything in the decision that says it was a complex decision and explaining why it took him some time. So I think when I reread Nicholson, I think the focus has to be on the record and not necessarily the magic words in the judge's decision. And so why would 24 days after the court took it under advisement necessarily be an unreasonable period of time for him to make that decision?
Your Honor, 24 days is not the correct time standard. Under this court's decisions in Nicholson, and Ungacta, and Kinata, the court has always held that you start the time clock, you start the counting of days between the date that the motion was filed, not the motion that was taken under advisement. Otherwise, you would invite the trial judges to just hold it and wait to hold it under advisement for days or weeks on end. And Your Honor, I disagree with your reading or interpretation of Nicholson. I know you wrote it, but Your Honor, your statement in Nicholson is very clear. It says the record should reflect that the trial court was diligent in working toward a prompt disposition of the motion and should make specific or reasonable statements that the motion to dismiss was novel or complex, which may constitute good cause. Now, if the court's going to—
Isn't that only focused on when the delay appears unreasonable on the record itself?
Yes, and 48 days is unreasonable and inordinate in this case. We have a beginning time of 32 days in Ibanez, 33 days in Kinata, and we have an outside time of 9 months in Nicholson. 48 days falls somewhere in between there. And is the court going to hold that 48 days is inordinate and unreasonable, or is it reasonable? And is the court then going to hold, well, maybe 60 days is okay, maybe 75 days is okay?
So is all of that time frame then excluded, or is a certain portion of it would be excluded? Are you suggesting that the entire 48 days should be excluded?
Your Honor, all of that time frame, the 48 days should be excluded, and I'll tell you why. If Your Honor's engaged in analysis of, well, you know, we think 30 days is good, we're just going to exclude 30 days, but maybe it's more complex, we'll exclude 40 days on the motion to suppress, because that required, you know, witnesses and other hearings. Then going back to Justice Carbolito's point, then you're going to engage in a fact-intensive analysis and looking through the record and trying to second guess the trial court on whether or not a delay is unreasonable or not. I believe that on the facts of this case and the court's prior holdings in Kinata, Ungacta, and Nicholson, 48 days is unreasonable and inordinate. And this is the most straightforward issue on this appeal, Your Honors. If you find that the first motion to dismiss and the 48 days to decide it was unreasonable, and the record is clear that the trial judge wasn't diligently working toward a prompt solution of the motion, the writ should issue. That is the most straightforward issue on this appeal. The second one is the motion in limine. Even if the court finds that the first motion to dismiss did toll the speedy trial clock, but the motion in limine did not, the writ should also issue. Because if you count the days from November 25th and 60 days later, trial should have commenced on January 24th, and it did not. I see that my time is almost up. Unless there are further questions, I'm going to reserve the last several minutes or 5 minutes for my rebuttal.
All right. Thank you, Attorney Ariola. Attorney Wallace-Chuck, you are recognized.
Chief Justice, may it please the court. The petitioner is asking for extraordinary relief in this case. He is asking this court to direct the lower court to dismiss the indictment against him in his criminal case. And he has not made an adequate showing to merit that kind of relief. So we're going to ask that you deny the petition.
If the court were to grant the writ, would it be with prejudice or without?
Your Honor, our hope would be that it would be without prejudice, but I believe the defendant is asking for with prejudice because he keeps saying that what the court did and what the people did was so egregious. I don't see it as being terribly egregious what happened, but I think that's what they're asking for here. That's not what we think the court should do. The rule in this case starts with arraignment. If you look at section 80.60, subsection A3, if you want to assert your speedy trial rights, that happens with arraignment, and then there are 60 days, and then some actions can toll the 60 days. In this case, the defendant asserted and was arraigned on October 8th. I think there was some argument earlier, maybe at one of the hearings, where the defendant was saying that he asserted on October 1st, but that is not the operative date, because that is not the date that he was arraigned. It starts with arraignment, because that's what it says in the statute. And then if we go all the way to the end, which would be when Judge Barcenas issued his decision and order on the second motion to dismiss on March 5th, that tells you the entire time that's at issue here. And then you can take out the days that were told by the actions of the defendant. So in this case, we have 2 motions to dismiss. We have we have an argument over a motion in limine about witness availability. We have.
Before we get to the tolling motions, Ms. Wallace-Chuck, I want to go back to the test for determining the trial commencement date. The government argues for the test, I believe, that it commences at voir dire as long as the court acts in good faith and doesn't espouse the Reinhardt test that the defendant argues for. What would be an example of bad faith besides the example from Reinhardt, where the judge, said, well, the only reason I'm impaneling a jury on this date is to avoid a dismissal under Section 1382. Give me another example of what may constitute bad faith for a judge to not proceed with the trial at voir dire. And then after I hear that response, I'll have a follow-up question.
Your Honor, nothing is really coming to mind right now. I know that the example in Reinhardt had to do with a judge who, I think he had 2 trials going on at the same time. He had one trial that was already in progress, and he had another one that had to begin, and it had to do with a congested docket. So in that case, the judge had so many cases. Here, that's not what happened, because Judge Bordallo knew that another judge could be appointed to replace him at any time. We don't have that kind of congestion problem here like they do in California. It's not really the same. And that's why I'm having a hard time coming up with an example that's not something nefarious. Like I guess. Well,
what about the government's argument that the defendant's argument that, well, Judge Bordallo never had in his mind to actually conduct the trial. And so he essentially just started voir dire because he wanted to toll the speedy trial clock with the selection of the jury. Why wouldn't that the actions constitute bad faith in that example?
Your Honor, that wouldn't be bad faith. I think that's actually a slur on Judge Bordallo. He's always been very professional and had a good reputation for acting in a judgely manner. I cannot see him doing something like that. We all know what he's like. Plus, Judge Bordallo must have known that he could be replaced quite easily, because there's a whole court of judges, and there is the computer system that assigns judges at random if they do need to be replaced. And so he did request that be done, and it was eventually done. I'll go on next to the motions. For the first motion to this.
Does it matter in this case that there were going to be substantial questionnaires going to potential jurors? Did it really matter if it was the trial judge who started that process?
Your Honor, do you mean the trial judge starting it as opposed to someone else? Because
well, if we assume that Judge Bordallo knew he would be stepping down at some point. But he faced sending 300, it sounds like to me it was around 300 questionnaires out to jurors. The parties had stipulated to dismiss for cause based on the questionnaires. So there weren't actual jurors in the courtroom. Couldn't any judicial officer start that process when you're not face to face with the jurors yet? Wouldn't that commence the trial? Did it really matter whether Judge Redalia would be there to start the evidence and so forth?
I'm not sure about that, Your Honor. I think that if voir dire is happening, then the judge should probably be present for that. I know that the jurors fill out the questionnaires and they can do that, you know, in their own time. But once the parties start reviewing them, the judge should also be involved. So in that case, the judge did allow some time for reviewing those questionnaires. So when you look at the jury selection dates, that's why there are small gaps between them. You go from the 10th to the 14th to the 17th to the 21st to the 22nd. You know, the petitioner wanted them all in a row, but I don't think under these circumstances that would have been possible because the parties need to be able to review it. If the judge had gone and done it every day in a row, then the defendant would be complaining that the judge crammed everything in too little time. So I think what Judge Bordallo did here was perfectly reasonable. Another thing I wanted to address was the motion about the video. I think the petitioner said in their reply brief that, you know, we didn't cite any cases that, you know, that a motion in limine that's decided amongst the parties themselves without the court's involvement, that doesn't count against the person who filed the motion. But I would say that goes against the spirit of the rules. That sort of thing should count against the person who filed the motion because the court doesn't know ahead of time that the parties are going to resolve it themselves. And so the court needs to be prepared to look for the opposition and the reply and set a hearing and then take it under advisement and issue a decision and order. So in this case,
that's really not that important in terms of the total time frame that we're talking about here. I think you know, Attorney Ariella pointed out, I think that the examination of the 48 days for the tolling of the motion to dismiss the indictment, and then the 37 days to decide the motion in limine on the prior testimony are really where the focus should be. And I know the government argued that it was 24 days between when the motion was taken under advisement and when the decision was issued on the first motion. I think it was a comparable period as well in the motion in limine. But why shouldn't we look at the time between the filing of the motion and the conclusion of the hearing on that motion? I mean, if you have the briefing, if a judge sets an expedited briefing schedule and all the thing is briefed, and then the judge delays in holding a hearing on it for, you know, 3 months, and then has a hearing 3 months down the road, and then issues his decision 2 days after the hearing. And is it your belief that we should only focus on the 2 days after the judge took the matter under advisement? I know that's the rule in the federal court, but we don't have that same statute that exempts the period of time during which the motion is outstanding and through the conclusion of the hearing, from the filing of the motion to the conclusion of the hearing. So why should we ignore the period of time between the filing of the motion and when the judge takes the matter under advisement?
Your Honor, if you look at when somebody files a motion and then there's an opposition and a reply and a hearing, those things usually go according to rule. So from case to case, it's going to be not terribly different. Where things differ will be in how long a matter has been under advisement. So in one case, it was, just a matter of 30 days or something. In the Nicholson case, it was, many, many months. So in this case, if you look at when the motion was filed and the opposition reply hearing, and then when the decision and order came out, that will tell you whether it was proceeding in a reasonable manner. You need to look at the timeline and not just the entire time. You should look at the dates between events that happened. So for instance, on the first motion to dismiss, it was filed on October 8th, but then there's a hearing, 3 weeks later on October 31st, and then the decision and order comes out, 3.5 weeks later. That's not an unreasonable amount of time considering what the judge had to decide.
Did the briefing on that motion follow the local rules, or was there a schedule set by the judge on that?
Your Honor, I think it followed more or less the local rules because I think the opposition, there's 14 days to file the opposition, and they had it in 13 days. And then the defendant was very interested in expediting matters. So he filed his reply 2 days later. And then the judge held a hearing 2 days later because he knew that the defendant was in a hurry. So it ended up being a little bit more expedited, but I think the people needed some additional time. I mean, they needed their real time that they're entitled to respond to the motion. Like the way that the petitioner—
So you agree that we should examine the time between the filing of the motion and the issuance of the decision and not just focus on the period of time under advisement?
Your Honor, I would say both because, when the motion is filed and then when the decision and order comes out, that entire period would be the tolling period. So you have to look and see if the events that happened during that time happened in a reasonable time frame. And in this case, they did, because they were sort of compact together. If you look in the Nicholson case, they weren't. The decision and order was very spread out. But to listen to when you listen to the petitioner, like the petitioner seems to be saying, that the people aren't entitled to even have time to respond. I mean, it's part of due process that if one side files a motion, the other side gets a chance, an opportunity and notice to be heard. Notice and opportunity to be heard. That's just a matter of due process. If we filed a motion
so let me, if I may just, so it's just so I understand your argument, because I'm a little confused, your opposition brief, and I thought that the focus was just from the time of hearing submission until the decision was issued, in which we are to determine the reasonableness of addressing it. But you're now contending that we look at the whole time period from the time of filing the motion to the time the decision was issued for purposes of determining the tolling, but for purposes of determining the reasonableness, we only look in terms of the time period of issuing the decision, we only look at the time period from the time it was submitted on the hearing to the time that it was decided. That's how I understand your argument from your opposition brief. Is that correct?
Yes, Your Honor, except I would say that goes for this case because the petitioner is blaming the judge for taking too long to decide and issue a decision and order. If there were some other case where—
Yeah, we need to have a consistent process. And so and I think the example that Justice Torres pointed out, I mean, if you have an instance where you have the defendant filed the motion to dismiss on January 1st, and then the court doesn't schedule the hearing until September 1st, and then issues a decision, as Justice Torres mentioned, on September, say, 5th. Your approach is that we only look at 5 days to determine reasonableness, and that's reasonable. Therefore, the whole time period is told from January 1st to September 5th. I don't think that's really how you want this court to analyze reasonableness, do you?
No, not at all, Your Honor. The reason I didn't spell it out completely is because in this case, when we have the motions that are filed and the opposition reply and hearing, they all happen within the bounds of the rules of the local court rules. If you had something strange, like the example that you gave, where somebody waited 9 months to set a hearing, you should be looking at that. But in this case, that didn't happen. That's why I'm saying that the only thing that varies here that's going to be show any unreasonableness is going to be the time under advisement. So if you look at the time under advisement for the first motion to dismiss, it's like 25 days. That's really not very much. For the second motion to dismiss, it's 30 days. For the motion in limine, it's 24 days. These are all reasonable time periods. Sorry, I misspoke. For the second motion to dismiss, I think it was under advisement for 6 days, 5 or 6 days. It was just a handful of days.
Let's
So I
go to
guess
the motion. Go ahead.
If I could just ask one follow-up. So my question then is that if we were to compute those days in reference to the first motion to dismiss, and from the time of filing to the DNO is 48 days, and the motion in limine, just as to the prior testimony, and not even take into account the body cam motion in limine. There, the motion in limine, so the motion to dismiss time period is 48 days. And the motion in limine from the time it was filed in December 31st, 19 until the time voir dire commenced, that's January 10th. That's 10 days. Because I don't think you're contending that the time period all the way up till the DNO in February 7th should be included, just when voir dire started, as far as the motion in limine. Is that correct, the 10 days?
That would be, Your Honor, that would be if the defendant is contending and the court agrees that trial didn't start with voir dire. Our preference would be the rule that trial commences with voir dire. But if you were going to accept a rule that didn't say that it starts at some other time, then we would say it's the longer time period, which is the 38 days. But
so assuming that the trial commenced when voir dire started, and that is on January 10th, so that will be a tolling of 10 days.
Yes, Your Honor. It would be a shorter time period.
So I guess my question, which I asked then again, Attorney Arreola, is even if we were to discount, assuming those are the time periods and those are determined to be a reasonable time period, and the trial commences upon voir dire, and so does it make any difference in reference to any delays on the part of the appointment of the second judge, Judge Barcenas, in reference to the tolling of the 60-day time period?
There's going to be enough time left on the clock, Your Honor, even if you include those 12 days where Judge Barcenas was off island. So what happened here is that the clerk of court decided that on January 22nd, it's going to be Judge Iriarte. She gets the first assignment. The defendant refused to waive that. She had a potentially disqualifying fact that we really don't think is terribly disqualifying, because that prosecutor is no longer at the AG's office and he is not handling this case, the one who's related to Judge Iriarte. But he refused to waive, and that set in motion the other judges being reassigned. So first you had Judge Sokola, and then you had Judge Barcenas. That is not a long delay. Like the petitioner was acting like assigning a judge took such a long time here, but basically it went from the 2nd to the 23rd. It took a day to get to Judge Barcenas. And then Judge Barcenas was off island for 12 days. So that's not gonna count. You know, that's gonna use up the speedy trial clock, because Judge Bordallo was either ready and available to go to trial and take it to conclusion, or he knew for a fact that somebody else was going to do it. That's why he was able to start voir dire when he did. So in this case, if Judge Barcenas had been on island, he could have started immediately. Since he wasn't, they had to wait a few days, but that did not run out the speedy trial clock. And so there was no speedy trial violation. And so therefore, this petitioner is not entitled to have the writ issued.
If we accept the argument that jury trial did not commence on January 10th when voir dire happened, but has still not commenced, would the filing of the second motion to dismiss on February 4th then toll the speedy trial clock?
Yes, Your Honor, because that's the defendant's motion, and it's for the benefit of the defendant, because it was a motion to dismiss.
So if you have from arraignment on October 8th to February 4th, you have 120 day after arraignment. So if we exclude from that the days for deciding the motion, if we determine that it was reasonable and it was told, and we assume that the motion in limine, and I want to talk about the motion in limine and focus on whose benefit the motion was on in a second, but if we assume that period of time was also reasonable and was for the benefit of the defendant, then it appears that we still have sufficient non-excludable days of delay that are available within the 60-day time frame.
Yes, Your Honor, that's correct, because you would have 120 days minus 38 minus 48. So that's plenty of time for jury selection to begin now and trial to go forward. There's no speedy trial violation in that case.
All right, so let's focus on this motion in limine, because the petitioner does reference the fact that the government, it was the government who intended to use the prior testimony of Dr. Espinola, the FBI agents, Josh Friedman, Jeremy Fletcher, and the GPD officer, Menno and Pendleton. And it was really that testimony, to read that testimony into the record was to benefit the government. And so they filed the motion in limine to exclude that. And part of the argument is that shouldn't count against them, because it really wasn't, besides the delay portion, they also argue that it shouldn't count against them because it really wasn't for their benefit. And they said that Judge Bordallo didn't even count the motion in limine against him when he did the calculation of how many days under the speedy trial clock had run as of January 8th. Was that the case? Did the judge not count that motion in limine against the defendant in calculating the speedy trial on January 8th?
You know, I'm not sure, Your Honor, what Judge Bordallo did. We would prefer that this court, in reviewing what happened in the court below, that those days be excluded. But I understand that there's a dispute with the defendant as to who benefits from this. I don't know how the defendant can say that they wouldn't benefit from having the motion granted, because then there goes the government's case. Those are all, you know, excellent witnesses who had important things to say about what happened here, and they would be very important in getting a conviction. So to exclude that would definitely benefit the defendant. That's why we say that this is the defendant's motion and not the people's. But I understand they are arguing otherwise. But
so would the same hold true for the notice of intent to use the prior testimony of Dr. Cohen and Ms. Tenorio and Ms. Rizzula and Dr. Stewart that the defense brought in? So are those for the benefit of the defendant? And then what is the period of time we would exclude for that. You didn't file any opposition to that. Do we wait until the time has passed for you to file an opposition and made a decision and count that as reasonable? Or when you, or how do we treat that scenario?
Your Honor, I think the reason that the people didn't oppose that is because the defendant needs to be able to put on a case, and they need to do it in the most, in accordance with judicial economy. And I believe that counsel is now appointed. And so this is not the kind of motion that the court would be likely to deny the defendant. And just as a matter of, fairness and due process, the defense gets to put on their case. So they would have needed those witnesses just like the people need the witnesses. So if the defendant gets to have the witnesses who aren't available, the same should hold true for the people as well. Because we are also a government agency, and we are also constrained financially, just like the court is when they appoint counsel for defendants. So one moment, please.
Ms. Polachek, I want to ask you the same question I asked Ms. Ariola. Why do you think section 80.60 applies to retrials on remand?
I think it applies here, Your Honor, because it's just so fundamental to be able to have a speedy trial right. I think that if they had meant
Is
to—
the Sixth Amendment a sufficient protection on remand?
I don't know about that, Your Honor, because if the legislature had intended this to only apply for your first trial, then they probably would have said something. The fact that it's not in there means that it probably applies when you go to trial. So
But there's nothing in the language of section 80.60 that talks about events following a remand. It doesn't talk about the clock starts running on the date the mandate issues. It doesn't talk about the defendant has to assert a speedy trial right, as Ms. Ariola suggests. It seems to me all the language of 80.60 refers to are the first trial.
maybe Your Honor is correct. I'm willing to concede that, but I don't know the answer. I'm sorry. I don't have a good answer for that. One of the things that the defendant was saying here is that the judge was just paying lip service to the speedy trial statute. I totally disagree with that. That is pure speculation. When the defendant had the second motion to dismiss, they subpoenaed the clerk of court, and she came in and testified. And unfortunately, she didn't know the answers to a lot of the questions that they had. But you know who would have had those answers? Is Judge Bordalio. He no longer worked at the court. Why didn't they subpoena him and have him come in and testify as to, why he did what he did? I just don't see it. I don't see that the judge in this case was paying lip service to the speedy trial statute. I think that he was doing what he was supposed to do. The petitioner goes on and on about how Judge Bordalio was working on other cases, and sorry, I ran out of time, but I just want to finish that he was working on other cases, but he's a judge. That's what he's supposed to do. He was doing his job. This defendant is not the only defendant in the world, and he's not the only asserted defendant. And there are lots of other cases, and Judge Bordalio had to do his work and finish up and get ready to leave. Thank you, Your Honor. We ask that you deny this petition.
Thank you, Attorney Wallace-Chuck. Attorney Ariola, you have what's indicated 3 minutes, a little over 3 minutes remaining. Please proceed.
Thank you, Your Honor. I do want to address some of the questions that were asked by the justices during the government's argument. Justice Merriman discussed section 80.60 again. And Your Honor, 80.60 refers to dismissal of a, quote, criminal action, end quote. Doesn't say whether it's on remand or not on remand. It's just a criminal action. And this case is a criminal action that was on remand, but the statute makes no distinction between whether it's on remand or not. Because this is a criminal action, section 80.60 applies. And Your Honor, Justice Carbolito, in reference to your question about, what about if there's an ill judge? The difference in this case is that the resignation of Judge Bordallo was foreseen. It was anticipated. His January 8th memorandum made that clear. You can't foresee when a judge gets ill. You can't foresee when someone is incapacitated or dies, but you can foresee when a judge says, I'm leaving and please reassign this case. And it's because of that that this judge was not available or ready to try the case to its conclusion. One of the things that the Reinhardt court said in its decision is something that it said after the test is that a judge has to be ready and available to try the case to conclusion. And after that, the sentence says, the court must have committed all of its resources to the trial, and the judge and the the judge and counsel must be ready to begin the trial. That didn't happen in this case. No matter which way you cut it, whether you say bad faith, good faith, intent to pay lip service, availability, unavailability, that didn't happen in this case. One thing that
let's say that we accept that argument, and so we look at the period from the arraignment to let's say February 4th, when you filed the motion to dismiss the second motion to dismiss, the second motion to dismiss. So we have 120 days for that period of time, right? And if the 48 days we determined was reasonable, and the 37 days for filing the motion in limine, and I want to talk to you about the benefit of that motion in limine, was a reasonable period. Wouldn't there still be enough days to complete the trial? Wouldn't the speedy trial clock still then not have run?
Under that scenario, yes, except that we don't believe that it should be counted that way. We believe that the first motion to dismiss and the motion in limine should not be counted against the defendant. One thing that the government's counsel misspoke about is the rules here. We don't have any criminal rules relating to the filing of motions and hearings. Maybe we should, but we certainly don't have that now or in this case. And so
in this case, how was the scheduling determined for the reply, the opposition and the reply briefs on the motion to dismiss the indictment?
It was ad hoc, Your Honor. It was based upon what the trial judge scheduled and ordered us to do. It was unlike the case in Carver, for example, where the trial judge immediately had shortened time, expedited briefing, and expedited hearing. That didn't happen in this case. What we had was a trial judge who told us when, where, and how to submit the briefs and the hearing. The questions that you asked previously and the other justices
Was there any objection, Attorney Arreola, at the time the judge issued that briefing schedule? Was there any objection?
No, there was no objection, Your Honor, but it's not incumbent upon the defendant to request an expedited hearing or an expedited briefing date. We could certainly have anticipated that the judge would take the briefs under advisement and the arguments under advisement and then issue a decision speedily, but that didn't happen in this case. And just in terms of the questions that Justice Torres was asking about, do we take it, do we count from the time taken under advisement? Well, Your Honor, some motions are different from other pretrial motions in a criminal case. A motion to suppress might take way more time than a motion to dismiss the indictment. To get into that, once again, is for the justices to be looking over the trial judge's shoulders and to be saying, is this a difficult motion? Is this not a difficult motion? Should I start from this date or not that date? And this court's decisions and this court's precedents are very clear and have been followed significantly by the trial court judges. And that is, we start from the date of filing of the motion, and then we see how reasonable that time is. In this case, 85 days to decide the first motion to dismiss and the motion in limine are unreasonable taken together. Taken apart, they are still unreasonable and inordinate. In this case, and we
Let
haven't
me,
even
let me
come-
ask you one other question, Ms. Ariola. You mentioned and criticized the judge working on other unasserted matters during the pendency of this case and the assertion of speedy trial. Is it your position that during the time that a speedy trial right has been asserted, that the judge should not work on any other matter, but focus only on this speedy trial cases?
Not at all, Your Honor, but I am saying that 48 days, which constitutes 80% of the 60-day deadline, is unreasonable. I mean, I think that's pretty clear. That's pretty clear cut. You can't argue against that. It's 80% of the 60-day deadline. By that time, in November 25th, when the decision issued, we were ready to go to trial. We were ready to go. You know, that didn't happen. Now, the government also mentioned something that I think needs to be clear. She said, you know, this is not the only case. We're not the only, you know, there were other defendants who had asserted their speedy trial rights. Actually, let me make this clear. At the time of the Saipan Judicial Conference, our case was the only asserted case. Think about that for a moment. We were the only asserted case while the judges were in Saipan for a judicial conference. So when we talk about, you know, paying lip service to the Speedy Trial Act, that's paying lip service. I mean, Your Honors, whether or not you hold that the first motion to dismiss or the second motion in limine, you know, told or did not told the speedy trial clock, what we have here is we have a situation where, what does it say about our judicial system that it's okay for judges to go to a Saipan judicial conference when a defendant has asserted his right to a speedy trial and he's sitting there waiting for his trial to begin? Or that jurors who were summoned and were voir dired are still waiting today for this trial to take place. Under Lewis versus Superior Court, a judicial conference cannot and should not take precedence over a defendant's right to a speedy trial.
But isn't it true then, Attorney Ariola, that the reason why it hasn't proceeded is you filed a motion to stay this action while this writ is being examined and decided?
Yes, because we believe that his speedy trial rights have already been violated. That the time
I think you should say that, you know, it's the examination of those issues prior to the motion to stay the proceedings, and not that it hasn't continued because of the actions of the courts.
That's correct, Your Honor. But the fact is still the case that the jurors were summoned, they were voir dired, and even up until the time that we filed the motion to stay, they're still waiting. So I agree with you, Your Honor. Everything before our motion to stay has to be scrutinized. But on the facts and circumstances of this record and this case, we ask that the court grant our petition for a writ of mandate and dismiss the amended indictment, because this court needs to send a clear message to the Superior Court that judicial conferences and administrative matters must yield to a defendant's right to a speedy trial. It must reaffirm this court's precedents that our decisions mean what they say. If you're going to decide a pretrial motion on an asserted case, give us a reason why it's taking so long. Tell us whether this is a novel or a constitutional or a complex case. And finally, we ask the court to find that the voir dire of jurors does not commence a trial unless the trial judge is ready and available to try the case to a conclusion. Unless this court has any questions, any further questions.
I do have a question.
Yes, Your Honor.
Why do you argue this writ should grant a dismissal with prejudice?
Well, Your Honor, I do recognize that this court's precedents say that a case should not be dismissed with or without prejudice unless the trial court is first given a run at it, and it should be the decision of the trial court. But I believe that in this case, we meet all the factors. I know it's a rare case where the Supreme Court or any appellate court for that matter comes forward and dismisses a case with or without prejudice. But I think that the court should realize and remember that this is not just a regular run-of-the-mill case. This is a case on remand. Our client has been under house arrest now for years. And you may not think, we now all know with the coronavirus and COVID-19 that being under house arrest and being at home is not all it's cut out to be. But when you're under house arrest 24/7, his liberty is still deprived. And so we would ask the court to take a look at the facts of this case and find that Even under the circumstances of this case should be dismissed with prejudice. If not, that it should be remanded to the trial court, and the trial court should exercise its discretion on whether or not it should be dismissed with or without prejudice.
Thank you.
Thank you, Attorney Ariola. Thank you, counsels. So this concludes our oral arguments, and the court will take the matter under advisement, and the court stands adjourned.
Thank you, Your Honors.
Thank you.